My lord, please see, my lord, then I'll read, my lord, what is their reason, because it's not my function to answer that. That's a political debate
The
or
governor has to ask himself this
On
question.
lighter side, you can very well say, staying together for 3 years cannot be said to be a happy life by that itself.
But the governor has to ask himself this question. What were you fellows doing for 3 years?
Lord, governor has
You're not in 1 month after the election has taken place.
my lord, kindly come to
1
page,
month after the election takes place,
Lord,
the
I
chief
have not-
minister suddenly breaks up with the, bypasses the BJP and joins with the INC. And
Lord,
governor can say, sorry,
must,
there's a
Lord-
serious discontent in the party.
Lord,
3 years you cohabit, and then suddenly one fine day, a group of 34 say that there is discontent.
kindly allow me to
They
place
all
what,
went and became ministers.
Lord, the difficulty is, my lord, out of, my lord,
Enjoying the spoils of office, and then suddenly, one day you just.
Wake up to the fact that
I leave it to your lordship. Well, that's a political debate, but I have an answer. If your lordship allows me, I'll answer.
You can go to the law council.
Yeah, now Chela shows the law now.
Huh?
I will.
You
But
take
before
us to
that,
the
let
law
me
first,
answer.
then
Let
thereafter
me answer.
apply the later.
Well, let-
Please do one thing. You can show the law, correct? Power of the governor, what can be waged with the government, and thereafter you take it to take us to the later, that whether it fits in that law or not.
My lord, kindly, my lord, note here at this page
Yeah.
14 is the answer. I'll come to it later.
All.
Page 14, why this 3 years of cohabitation, my lord, and why thereafter, my lord, a divorce. I'll answer, my lord. They have answered to me. They have shown it to me. Me means the governor. The governor is given why we have been together and now what are why it's now or never situation, my lord. That I'll kindly, my lord, allow me to place it at page 14, my lord. Now, your lordships, my lord, kindly take these propositions, my lord, and that would, my lord, perhaps answer your lordship's questions. Because otherwise, my lord, I may not be able to fulfill my promise of, my lord, concluding in.
No, you are right, absolutely. I took some time out on asking.
No.
You're right, absolutely. No.
As,
It's just that sometimes, you.
on, just not on a lighter
Just
side.
get- no,
When
no,
the court is quiet, my lord, as I said, the arguments are longer. And, my lord, just since everything is, my lord, now very, very serious, and I want to start the new point not on that serious note,
let's see that.
kindly allow me to use, my lord, one, my lord, kindly, before your lordship takes the proposition. Before your lordship takes the proposition, my lord, on a little light note, I'll start. But there is a Urdu couplet, Mr. Sibal is fond of, my lord, both of us share that. There is a very good Urdu couplet on the situation which is arising. मैं चुप रहा तो और गलत फहमियां बढ़ी. This for the court. When the court is quiet, then we don't understand what is passing in the court's mind. मैं चुप रहा तो और गलत फहमियां बढ़ी. वो भी सुना है उसने जो मैंने कहा नहीं. So, this is.
सुना है उसने जो मैंने कहा नहीं.
वो भी सुना है उसने जो मैंने कहा नहीं. मैं चुप रहा था. So when your lordships are quiet, we understand that there are 10 points.
Mehta, पर वो भी सुना जो मैंने कहा नहीं. What we in legal parlance call reading between the lines.
But those who write shares, they don't write for legal documentation. They write for some particular person. They write for one individual. That one individual is relevant for them, those who write.
By the way, who is the author of the couplet, Iqbal, or who is it?
No, this is Wasim Barelvi.
Oh.
Very fine. One of the top ranking alive poet who is alive. Contemporary Urdu.
By the way, Mr. Sibal, I don't know if Mr. Tushar Mehta, whether you've read this book called Dilli O Dilli, which is written by one of our lawyers.
Yes.
Supreme Court Bar. It's
Yes,
a beautiful book on,
Beautiful, yes.
on a variety of Urdu poets.
Yes.
Yes, Delhi had that tradition, now it's dying. Unfortunately, the best tradition was in Lucknow. Lucknow also, I asked people that there's a dying tradition. In Allahabad also, Firaq Gorakhpuri and all, my lord, now that tradition is fading away. I'll not say dying, but it's fading away, my lord. It's not. But there are young, my lord, writers.
It's an
they
issue
write.
of language, Malad. Actually, language is taken over. And Urdu is a dying language as of today. That's the reality. And therefore we are losing a lot of that culture. That's what it is.
Yes.
You'd like to go through your propositions?
Yes, my lord. Kindly, my
Let's
lord,
quickly
come.
go through your propositions, so then we are done. We
My
just
lord,
then look at the
para 4.
judgments.
Para 4, my lord. Para 4. This expression I have borrowed from Bomai, from wherever derived, because this was an expression used by the committee of governors appointed in 70s, and Bomai has approved that report, my lord. Can only arrive at a conclusion that prima facie the cabinet or the chief minister has lost confidence, support of the house, which requires to be tested on the floor of the house. His satisfaction is limited only to the requirement of floor test and not whether A enjoys majority or B enjoys majority. Now, my lord, your lordship's very pertinent question was that if, I'm sorry, my lord, your lordship, sorry, that merely because there is some internal dissatisfaction amongst the party, can the governor take this call or not? My lord, a similar question arose, my lord, in case of Rameshwar Prasad, where the question was that you're permitting somebody to request you to hold a floor test would violate 10th schedule. Because what these people, this group who is expressing no confidence against the chief minister, stand disqualified or will stand disqualified under the 10th schedule. And the question before the court was whether the governor, while taking a decision under Article 174 and 175, is concerned what will be the effect of their act ultimately in the 10th schedule. I hope I'm able to make myself clear. While taking the decision, I am supposed to be cognizant that what they are doing might be a reason for 10th schedule punishment, a consequence subsequently. Your lordships, my lord, through a constitution bench says no. My lord, please take, my lord, my lord, 2006, volume 2, SCC, page 1. I'll read only 4 paragraphs on this point. The governor is agnostic to 10th schedule. He has to be satisfied that the confidence is lost prima facie. It needs to be tested on the floor. They may suffer consequence, they may not suffer consequence. That's not the governor for the governor to see. That's what your lordships have said. Lord, kindly see PDF page 393 in JC volume 1.
There are two important things which the governor has not taken into account, which to my mind were extremely important. One, that insofar as the Congress and the NCP are concerned, there is absolutely no shaking up of there is no internal dissension in either the Congress or the NCP. Congress had 44 members, NCP had 53 members. This is a block of 97. There's absolutely no dissension in either Congress or the NCP. So in the 97 still continues to be a solid block. What is disturbed is, say, out of the 56 that the Shiv Sena had, 34 have expressed
which brings it down to your lordships are.
So out of the second thing which the governor had to bear in mind is this, that as of this date, there is not even a suggestion that the Shiv Sena is going to team up with the BJP to form the government. So that's again a circumstance which is totally alien to his consideration. So he can't be oblivious of the fact that in a 3-party coalition, the dissension has taken in one party out of the 3. The other 2 are steadfastly support the coalition, and they are not by any means, sidekicks. They are almost at par. All the 3 are virtually at par, except the Congress, which was a little lower.
May I only make one
lower than the.
May I only make one request? Look, to examine the facts of the case, after, my lord, I show the law, your lordships are shown, but some of the paragraphs, some of the law is unfortunately, my lord, not assisted.
2006.
Thereafter also, my lord, why the governor can take that step, even if NCP Congress bloc is not disturbed? I'll, my lord, answer that. My lord, it is para.
What is the citation, Mr.?
My lord, 2006, volume 2, SCC, page 1. Para 85.
Which compilation is it?
The judgment compilation 1. My lord, PDF page 482.
Starts from page 393.
Yes, yes.
Want to go to 482.
482, my lord. Para 85. I am reading 85, 161, 164 and 165, which is on this point, my lord. And my lord, kindly bear one factor in mind. My lord, whether the court would have taken the same view which the governor took may not be the test while determining, my lord, the decision taken by the governor. Court may perhaps on the facts arrive at a different conclusion. Lord, 85. Certainly there can be no quarrel with the principle laid down in Quixote case about the evil effects of defections, but the same have no relevance for determination of the point in issue. The stage of preventing members to vote against the declared policies of the political party to which they belong had not reached. If MLAs vote in a manner so as to run the risk of getting disqualified, it is for them to face the legal consequences. That stage had not reached. In fact, the reports of the governor intended to forestall any voting and staking the claim to form the government. Well, this was a case of 356. He sent a report that now dissolve the government. Yes.
The stark distinction, so far as Rameshwar is concerned, Rameshwar government was not formed. It was at the initial stage immediately after elections,
Correct.
where there was no party who got the majority. Instead of waiting for somebody to form a majority, the governor asked for dissolution of the House.
356. He exercised.
And the reason he has given is that if I spend more time to allow a coalition to be formed, they will cobble up a majority and thereby violate 10th schedule and then create a government. So court said the governor cannot assume that one of the political parties would go ahead, cobble up majority by coalition. This is a wrong inference that the
Yes.
governor has drawn.